Hello, my name is Tony Madonia, and I'm a CPA and an attorney in Chicagoland. My law firm does a lot of estate planning. We also do corporate and tax planning, and I've done a short video to discuss estate planning, particularly as it applies to people in their golden years. Today's subject matter is estate planning, particularly as we get into our golden years and what that looks like, who needs it, and how that should be prepared. I think to sum it up, estate planning really is deciding what you have and who you want it to go to, and making sure that it goes to who you want, the way you want, when you want, and at the least possible cost, both financial and in aggravation, because there's a cost to that too. So what does that mean? When we talk about estate planning, we talk about what a person's assets are. Oftentimes they'll own a home. Oftentimes they'll have a bank account, maybe an investment account, maybe a retirement account, maybe some life insurance, but as time goes on, it seems like fewer of us have that. And more importantly than that, talking about their family situation. Who are their kids? Who are their grandkids? Who are their other loved ones? What charities might they want to support with this? And what's the best way to do all that? So we spend a little bit of time talking about people's assets. We spend a lot of time talking about people's objectives and how they want their assets to be split and who should have access, and also who should be in charge of those assets while this is taking place. People talk about a will, and people seem to think that if they have a will, they're covered. We don't like will-based planning because we don't think it works very well. For example, while you are alive, your will doesn't do anything for you. So if you were to become disabled, nobody could interact with your bank, nobody could interact with the government as far as Medicare or Medicaid or Social Security disability, things like that. The will doesn't help you whatsoever. The other problem with the will is when you pass away, it becomes public. It gets published. And you can go to the 11th floor of the Daily Center and look at all the wills that have been filed. And there's personal information in there. Sometimes what people's assets are, sometimes who inherits money, sometimes who disinherits money. All those things that we've fought so hard to keep personal during our lifetime suddenly become public if you have a will. Rather than that, we do trust-based planning. And the beauty of a trust is it would help you if you are alive but disabled, and it remains private forever. Nobody else needs to see it. So for those two reasons, we like trust-based planning better. People talk about estate taxes. I would say most of our clients don't have challenges with estate taxes. The federal exemption this year is 13 point something million. That amount goes down to 6 million on January 1st of 2026, so about a year and a half from now. The Illinois exemption is $4 million, and that number is not slated to change anytime in the near future. So for many of our clients, the estate tax is not a challenge for them. Rather, disposing of their assets in an orderly and a timely fashion is the bigger challenge. We talk about trusts, and we talk about who the trustee is. And the trustee is somebody who, think of them as the power of the pen. They can sign checks, they can execute trades, they can make disbursements. They're in charge of this process. Oftentimes, trustees are clients' children, if those aren't good choices, as other close family members. In certain cases, it's a bank or a trust company, but not often. We usually find better choices than that, better being people who know of you and know of your values and know of your family, things like that. So those are the people who are in charge of those assets, both when if you become disabled and when you pass away. In dividing assets up, oftentimes it's divided by the number of children that the client has. Doesn't have to be that way. Doesn't have to be an equal distribution. Some children of clients don't receive anything for a variety of reasons. Some of them are well-to-do on their own. Others have fallen out of favor for one reason or another. But every single client situation is different. Certainly every family situation is different, and we treat it that way because we understand that it's important, and there's no other plan out there like it, each one of the plans we do is a custom-made plan. We like to keep the assets in trust for the future family members rather than distributing it to them outright. Reason being, if it's distributed to them outright, it is subject to their creditor claims if they happen to get sued. It's also subject to spousal claims. If they get divorced, those assets may become part of that divorce proceeding, and certainly nobody intended for that to happen. So our preference is to keep those in trust, dole those assets out as needed. If the child passes on with assets still in their trust, generally it would go to their children, the client's grandchildren, although certain clients have planned around that too. Certain clients want that money to go to a charity or to other family members. There's a million different ways to do it, but oftentimes those assets would go to the deceased child's children. Again, we like to keep it in trust for the reasons I mentioned a moment ago. Our trusts have something called a supplemental needs trust provision in them. And supplemental needs trust says if the beneficiary is disabled and would otherwise qualify for Medicare or Medicaid or Social Security disability or other government programs designed for disabled people, supplemental needs trust protects the assets in that trust so that the child still qualifies for whatever government benefits are available, and the assets are preserved for either the day that that child recovers from their disability, if it's an accident or a long illness, or upon that child's eventual passing. It keeps those assets in the family and makes sure that that child gets all the benefits that they would otherwise be entitled to. We've seen that come up more and more, particularly as people are living longer. That's a big part of the planning we do. So that's, in a nutshell, what trust-based planning is. The other big element of trust-based planning is that we have to transfer all the assets into this trust. So the client is the trustee, the client's in charge, and the trust will own all of the assets that the client owned before that. The trust will own the home, the trust will own the bank account, the investment account. The trust will be the beneficiary of retirement plans, because the trust will control what the trust owns. The trust won't control what the trust doesn't own. So a big part of what we do is transferring those assets into the trust so that we know that the trust will control all of the assets of this particular client. We do a will that accompanies the trust. It's very short. It's called a pour-over will. And a pour-over will says, if I happen to have any assets in my own name, pour those over into my living trust. We do that for a couple of reasons. If the client has an asset in their own name for whatever reason, and it doesn't happen often, but it does happen, this gives us a mechanism to transfer that asset into the trust. The other reason we do a will is it gives the executors that the client names the chance to file a lawsuit in the client's name. For example, if the bus driver runs you off the road and you're fatally injured, the executor can sue the bus company for damages. And we've seen that come up several times, particularly with the asbestos litigation that's gone on, previously with the tobacco litigation. Now we're seeing it with the pesticide litigation that's happening. So having somebody in place that can be appointed an executor can become very important. Other than that, the will is very generic. It says very little. If you happen to have children that are under the age of 18, the will also nominates a guardian so that people you've chosen would be in charge of raising those kids, making their life decisions, where they go to school, where they get braces, all those sorts of things. So we do a will that accompanies a trust. It doesn't say very much at all. It's really a belts and suspenders approach. Other parts of the planning process that are equally important, we do a healthcare power of attorney. And a healthcare power of attorney allows people that you've chosen to make your healthcare decisions for you if you cannot. While you're alive and able, you will continue to make your healthcare decisions. If there comes a day where you can't make those decisions anymore, then people you've chosen can interact with doctors, talk about course of treatment, and make all those decisions. It also authorizes that person to examine your medical records, disclose those medical records to third parties. If there's a reason to get a second opinion, they can ship your medical records to another doctor group who can then weigh in on what your course of treatment ought to be. So healthcare power is something that designates someone to make your healthcare decisions if you cannot. Coincident with that, there's a living will, which has nothing to do with a pour-over will, but a living will is a statement of your intent that if your condition is irreversible and terminal, you don't want life-sustaining treatment provided or continued. And it goes on to describe what irreversible and terminal means, and it also describes what procedures are that would only prolong the dying process. The idea being that if you're at the end of the road, please don't make you a science experiment. Let you pass with some dignity and let your family have a say in how that occurs. So that's what a living will is. We prepare something called a limited property power of attorney. So a limited property power of attorney allows people you've chosen to do a few things upon your disability that just don't fit within a trust. For example, they can communicate with government agencies like Social Security, like the IRS. They can bring lawsuits in your name if you're alive but disabled. The bus driver runs you off the road and injures you, they can sue the bus company. It allows them to open your mail. It's a federal offense to open somebody else's mail. It fills in a couple of blanks that just don't fit anyplace else, but it's very limited in its scope. People hear power of attorney and they get uncomfortable. We don't like powers of attorney. A power of attorney generally says you can do anything I could have, but it doesn't say what you want done. The trust goes into great detail about what you want done, so we know what you want done. The limited power of attorney lets you interact with certain assets on a very limited basis to make sure that the intent of the trust is carried out. While you're alive and well, the property power does not do anything. It only kicks in if you're alive but you're disabled. We make sure that the assets are transferred into the trust. We will prepare a deed for real estate, sometimes several deeds, sometimes deeds for property that are in other states. We transfer financial assets. We don't much worry about cars. They're generally not worth a whole lot unless it's a collector car that's got a high value, but we don't worry much about that. We make sure all of the assets are inside that trust. And then we're always available to answer questions. We get plenty of calls about, I'm opening a new account, is this done properly? Or sometimes people come in just for a checkup to make sure that the trust still fits in with their objectives, because over time it seems that people change, sometimes trustees change, sometimes beneficiaries change. We want to make sure that the document still meets the goals of the client at that particular time. If you're interested in learning more, there's information that you can get to contact our firm. I'm happy to have a conversation with anybody. If you have a plan currently in place, I'm happy to take a look at that, let you know ways that it still makes sense, maybe ways that it can be improved upon if there are any. But that consultation is free and without obligation, and happy to help with that. I appreciate the opportunity. I hope you have found this helpful. If you do decide to move forward with planning, I encourage you to contact our firm or any other firm that's qualified to do this. But this is important, and like I said, particularly as we approach our golden years, this becomes a little bit more timely. If I can answer any other questions, please reach out. Thank you. Bye-bye.